To give you an idea, it sets out circumstances under which land can be confiscated by the state without compensation, and some of those circumstances do not abide by the just and equitable requirements that are in our current constitution.
The Expropriation Bill is currently before Parliament. What are the legal implications for property rights in South Africa? Well, joining me to discuss is Advocate Mark Oppenheimer of the Johannesburg Bar. Mark, there are two parallel processes here. There's the Expropriation Bill and also the constitutional amendment process. What is the difference between these two processes, and what are some of the risks emerging for property rights in South Africa?
Well, let me start with the initial process being the move to change our constitution and amend the Bill of Rights for the first time in South African history. So government has gone down that path for a couple of years. The idea is to allow for the expropriation of land and improvements without compensation. So that would include things like your residential property, which attaches to your land, or a business which is on land, or crops, or farmland itself, or not just farmland, but urban and rural land. So that's a really big concern for South Africans, and it's something that is an ongoing process, but has stalled for now. As the pandemic started, government was on a provincial roadshow. There are certain public participation requirements, and that stalled. They have now gone ahead with the separate process, which is the Expropriation Bill. And government takes the view that that Expropriation Bill must comply with the Constitution as it stands. In my view, the bill does not comply with the Constitution as it stands. To give you an idea, it sets out circumstances under which land can be confiscated by the state without compensation, and some of those circumstances do not abide by the just and equitable requirements that are in our current Constitution.
So, Mark, what are some of the practical concerns that you have with the EWC bill as it's currently constituted?
So Section 12.3 of the bill sets out the examples where the state can confiscate land without paying any compensation. One of the ones that I'm quite concerned about is a case where someone buys land, and the reason why they've bought the land is because they expect it to improve in value. They haven't bought it because they want to develop it or because they want to improve it. Now, to my mind, there is nothing wrong with doing this. In other words, people buy shares because they expect them to improve in value. People buy all sorts of collectibles or other kinds of items because they want them to grow, and they don't necessarily dedicate their own labor to improving the object. So, for example, someone might think that the perimeter of a town might be good land to buy because the town will expand, and they sit on it for 10 or 15 years in the hope that it'll improve in value. If we think about, for example, the land owned by the Mears, which stretches through Waterfall Estate in Midrand, they held that land for decades without improving it. And once things became ripe, they then could develop the land and make a profit on it. Now, there's nothing wrong with making profits. Profits are an important part of an economy. The fact that we have a profit incentives means that people are innovative, that they will take risks. I mean, one might buy land in an area and it's not worth what you paid for it. It degrades. So people take that risks. And the idea that the state should be able to punish you because you take a risk in the marketplace with regard to land is unconscionable and unconstitutional. The other case that's a worry is the legislation says in the event that the land has got health hazards, that it can then be taken from you without payment. And so we can imagine a situation where someone buys a block of flats in town. It is then invaded by a building hijacker. The building hijacker then strips out the electricity or the sewage system and makes the place a health hazard. Now, that person is a victim of the hijacker. They've also probably a partial victim of the state because they've struggled to get that person evicted because there are so many procedural limits that make it very hard to evict someone. But then after you've gone through that trauma, now the state says, well, your building's no longer hospitable, so we're going to take it from you and pay you nothing. So you're getting whacked again by the state. And that again strikes me as something that is unconstitutional and unconscionable.
So, Mark, this EWC bill is often erroneously mischaracterized as a land reform initiative. It clearly represents, as you've laid out, a threat to private property rights. What genuine land reform initiatives could we undertake in lieu of this expropriation policy?
Well, I think when we talk about land reform, firstly, there's an ambiguity. So the one question is, are we talking about rectifying the wrongs of the past? And I think we have a moral obligation to do that. We must recognize that South Africa has got a dark history of people having their land taken from them forcibly by the state, and we shouldn't allow that to happen again. And we should provide compensation to those that had their land taken from them. But we must also acknowledge what has happened. So between 1995 and 2014, we opened up a land claims process, and 1.8 million individuals have received compensation through that process. 95% of the claims that were brought during that period have been resolved. So we can, on the one hand, say we have done a lot to rectify the wrongs of the past. Now, the other side of land reform is really about redistribution. And it's this idea of trying to take from some and give to others. And the idea is, well, this would be good to include more people in, let's say, farming. Now, one of the concerns with this is that it's tended to be a catastrophic failure. So, for example, in the Eastern Cape, government spent over R1 billion buying farmland. There were about 260 functioning farms that were then bought by the state, so they paid compensation, and then they distributed to other people. Now, over a 10-year process, 90% of those farms failed. So only 26 of them still operate. Now, there's a couple of reasons for this. One of which is that farming is a technical skill. It's not the kind of thing that anybody can do. Large-scale farming requires, the particular scientific knowledge to know how to get good yields out of your crops, but also business skills like knowing who to liaise with, who to buy and sell from, fluctuations in the market. And those are not the kind of things that can be done by anybody. So what you have then is that 90% of these projects fail, and then all the workers who are working on those farms are now left unemployed. So if what you're trying to do is help the poorest of the poor, you have a complete backfiring effect on that front. So I would think what you really want to do is you want to ensure that South Africans have property rights. So if we think about the Free Market Foundation's Kaya Lum project, what they've done is identify people who are living in state-owned property and have done so for 20 years, but have no title deeds. And the concern of not having a title deed is that you are then stuck with this particular piece of land. You can't leave it. So if your job changes, you can't go and sell that piece of land or borrow against it to start a business. And so they have moved to try and transfer people title deeds so they actually have secure property rights. And I think that's what we need to be doing, is ensuring that more people are property owners instead of destabilizing those that already are property owners.
Well, thank you very much, Mark. Let's hand it over to you, our viewers. What do you think is the real motive behind the EWC bill, and can it be stopped? My name is David Ansara. This is the Center for Risk Analysis. Until next time, take care.